You're going to give me the signal, right, Paul? We're good? We're live? All right. We're live, I guess. All right, let's get underway then. Good evening, everyone. I'm Blake Bingham. I'm the Assistant State Engineer for the Division of Water Rights, responsible for general adjudication proceedings. I'm the guy responsible for scaring you to death with a summons and a notice and a letter that's probably really confusing. We'll get to a little bit of that here in a little bit, but just before we kind of get underway, this is the Water Rights Adjudication meeting for the Provo City South Subdivision, Area 55, Book 6. You know, contrary to what you may have assumed based on some of the wording in the notice and the summons, which is kind of statutory language we have to put in there, you're not obligated to be at this meeting. This is just an information type meeting, all right? We're just going to put out some information, field what questions you may have. If you do have some questions that are specific to your specific case or your scenario, I just ask you to hold them off, and we will answer them afterwards. If you have a question that maybe is more of a broader application, maybe other water users would benefit from that question, please ask it at any time throughout the presentation. I'll do my best to answer it. If it continues to kind of, we chase rabbits down holes, I might just ask to table it and we'll proceed with the presentation just so that we can honor everyone else's important time here and kind of get through this, and those who want to stay can stay and those who don't can move on. With that being said, we are broadcasting this over the internet, live streaming it, and it's also being recorded, so this will be available, this recording will be available online tomorrow at some point at that same web URL that you received in your notice. For those of you who are viewing this online, you can ask questions. Simply email them to that email address at the bottom of the screen in bold blue letters. That's also an email address that any of you can use throughout the adjudication proceedings. If you have a question you want to ask, we'll get an answer to you. Here's our agenda for tonight. We're going to kind of go over the adjudication process in general. We'll talk about what a proposed determination is and the process behind that. And I know some of this lingo is probably not resonating with you yet, but hopefully by the end of the night it will. We'll talk about some of the significant issues and anticipated timeline and questions, okay? Again, if you have a question, raise your hand, ask away. You usually find out that people are pretty quiet until someone gets bold enough to ask a question, and then everyone feels a little bit more comfortable. So if you have a question in your mind, I'm pretty sure someone else in the audience probably does as well. When we have these public meetings, generally the understanding of water rights or general adjudication proceedings, span a huge spectrum, okay? And so we always like to start off and break it down Barney style a little bit and kind of build everyone's understanding up throughout the presentation so that everyone's on the same sheet of music by the end. So I start off with talking about what a water right is, and for some of you this may be old hat, for some of you this may be brand new, so bear with me. Water right is, as it sounds, a right to divert water from a natural stream or source and then beneficially use that water. It has a couple defining characteristics. It has a defined nature of beneficial use, or in other words, what is it being used for, whether that's being used for irrigation, stock watering, domestic uses, culinary uses, municipal uses. It has a priority date, and we'll talk a little bit about the concept of priority and how it relates to water rights, but in essence, a priority date tells you where in line that water right is in getting its water, how senior it is. In the western states, we typically operate off this concept of prior appropriation, where if you got your right first, you get your water before anyone else who got their right after you. So that's what the priority date kind of tells us where you're at in that pecking order. There's a defined quantity of water. We typically measure that either through cubic feet per second or an annual acre foot. Those are pretty common standard measurements for water. Those of you who are in agricultural will recognize them. Sometimes we say a second foot instead of a cubic foot per second to represent CFS. We have a specified point of diversion, which is really where you're taking the water out of the natural stream source. So if it's a well, that's your point of diversion. If it's a head gate off of a stream, that's the point of diversion. So just think where you're actually physically removing the water from its natural source, and that's what the point of diversion is. And then a specified place of beneficial use, and that's just like it sounds, it's where the water is being used. We identify that location using the public land survey system, so we'll get it down to the 40-acre tract that is associated with that use within the section and township and range. Again, that might be kind of some new terms to some of you, but don't be alarmed. We'll walk you through it if you have any questions. Some of the first questions we get when we send out that initial notice and summons is people calling up and asking us, well, how do I know if I have a water right? In a lot of areas that have been urbanized, such as Provo City, this used to all be kind of agricultural land, pasture land, and as it's kind of urbanized, people have subdivided their lots, but sometimes these wells will remain, or the uses for those wells will remain, but the people who have subsequently purchased those lots and moved into those homes don't really know much about water rights compared to the person who maybe originally appropriated them. So they'll call us up and we'll ask if we know if they have a water right, and we have some tools that we can look to see if we think that they may have a water right. But for your understanding, usually water rights are evidenced by having like a wellhead on your property, or maybe there's a gate or a ditch running through your property, some type of physical manifestation of where you're taking water out of the natural source, or a spring box is another example. Let's talk a little bit about what a water right is not. First of all, a water right and water shares are two separate things, okay? They're very similar in concept, and to the end user, they're very similar. But they're really two separate things. A water right is what the Division of Water Rights, the state of Utah, they control and they direct and they administer and distribute those rights. A water share is typically a share in a company, and the company owns the water right. So if a company might have a water right off of the Provo River for 50 second feet or 50 CFS or so many acre feet, they own the water right, and then they distribute shares to shareholders and distribute water to those shareholders. So what we are worried about, or what we are concerned with, is the water right. And so when we say you need to participate, it's really, in this case, the company, the water company, that needs to participate as the owner of the water right. Now, obviously, the shareholders have a vested interest in the company participating, so it's important for shareholders to understand the proceedings. And often, a lot of these water companies, some are more robust than others, have a lot more infrastructure, a lot more funds, and maybe even attorneys, and some don't. Some are kind of operated out of the glove box of a Chevy pickup truck, and that's all they got. And so we encourage people who are parts of these smaller irrigation companies or water companies to make sure that that company is participating, and we'll try to help all we can to make sure that the company's up to speed. All right, let's keep on moving along. So really to kind of understand why we're showing up in your neighborhood right now at this point in time, it really takes a little bit of historical context. So bear with me. I'm going to go give kind of a brief overview of water rights history in the state of Utah, because I think it's important to know where we came from to understand why we're here today and why you're in this room and why you received a legal summons, right? Something that's kind of scary and maybe intimidating, confusing. Usually when I send out these summons, I'll go onto Facebook and just kind of do a general search for like Utah water rights, and I'll see if there are any threads that are talking about these summons went out, and of course I do it here, and I see there's people questioning my intelligence and what the state's doing, questioning my pedigree. There's lots of that stuff, and that's just fine. It's perfectly understandable, and if I were in your position, I would probably be doing the same thing. So I'm here to kind of help bring you up to speed, and we can all get on the same sheet of music together, and you'll understand that really this is a process that was precipitated by other parties, the state, and I know this always sounds dangerous, state is here to help, right? But we're really to help you navigate this legal proceeding in the best way we can. So let's talk a little bit about the history of Utah and water rights. And we all know the story starts off with, at least the water rights story starts off with Brigham Young entering the valley. And in July 23rd, 1847, the Advance Party actually entered Salt Lake Valley and started diverting the waters of City Creek to kind of soften up the soil so they could plant a late season crop. And then, of course, they built the mall on top of City Creek. Well, about a year or so later, Brigham Young made this statement that you might say, it kind of is the undergirding element of water rights today. He said, there shall be no private ownership of the streams that come out of the canyons. These belong to the people, all the people. And so a basic and fundamental tenet of water rights is that the water is a natural resource. It belongs to us. As citizens of Utah, it belongs to all of us. It doesn't belong to the state. It belongs to the citizens, the residents. The state is simply here to ensure that those who have rights to divert their water have access to those rights, and those rights are protected, and so that we can distribute the water based on that priority system. Well, between 1847 and 1850, what we now know as Utah really kind of migrated through a couple different types of states, as you were. First of all, it was part of the country of Mexico, so it was a foreign country, and then it kind of turned into this semi-ecclesiastical state known as the state of Deseret, and then it finally turned into the territory of Utah. Well, even though it went through all of those, there was really just one group of people here, and they were trying to figure out the best way to make a living and divert the waters. And as a result of that, diversion from the waters along the Wasatch Front primarily was kind of done on a communal basis. Brigham Young would send parties north and south, and they would kind of try to etch a living out of the barren landscape as best they could. And part of that was diverting these streams and trying to irrigate crops, which was a kind of a new thing for them. They'd come from the east, rainfall was plentiful. Now they had to actually learn how to divert water and apply it to ground. So it was kind of an innovative thing. We kind of take it for granted because we've kind of grown up in it. But to them, that was a new ordeal for them. As the settlers would move into these communities, obviously the first settlers would do a lot of the initial work. They'd dig the main ditches and get the diverting works established. But you had follow-on settlers who would come, and recognizing the need to share as best they could, they still wanted to recognize that some settlers had put in a lot more effort than others. And so this concept of primary versus secondary water rights came into being, where you had those settlers who got there first and put in all the effort. They got the primary flow of the water. And if there was any excess water, then these other settlers could share in it. Again, this was a new concept that kind of had its birth in Utah, really, as it relates to water, and then spread throughout the West. Conflicts were generally settled by ecclesiastical channels, which is no surprise, right? There wasn't a power structure in place, and so the church kind of filled. When I say the church, I mean the Church of Jesus Christ of Latter-day Saints. The church filled that vacuum, and so they had bishops' courts that kind of acted as the local courts, and if you didn't like what the bishop said, you'd take it to the stake high council, and they'd kind of act as an appellate court and overrule the bishop's courts and those types of things. And that's just how they operated. So you can kind of see that there were some problems in that, especially if settlers came in that weren't members of the church. You can see how that might kind of not sit well with them. Well, as we get into the Territorial era in 1852, the first Territorial Legislative Assembly tried to break that up, right? They passed a law that authorized the county court to distribute timber and water and those types of things, but it was pretty much ignored throughout the state or the territory at the time. You can recall there was a lot of animosity between the federal government and the pioneers at that time, and so a lot of these things were ignored. And even where they weren't ignored, the county courts were really an elected position. And so you can imagine who the people were electing to the position of judges in those counties. It would be the bishops and the stake presidents. So there was really not a whole lot of change to how things operated. In 1877, the Desert Land Act was passed by the United States Congress. This was really an incentive for people to migrate to the West, to settle the West, to homestead the West. Some of the unintended consequences were they recognized that, unlike the East, where if you lived next to a river, you had an automatic riparian right, you had access to that water, and you didn't really need to irrigate because precipitation was plentiful. Well, in the West, that's not the case. You actually had to go and homestead a big, large 120-acre tract and cultivate it and demonstrate that you were able to do that in order to get your land patent from the government land office. Well, it's problematic because not a lot of 120-acre tracts have streams running through them. And so this concept of, well, you've got to divert the water from over there and then bring it over, kind of severed this concept that, hey, if you live next to a stream, you have an automatic right. It kind of reinforced that concept of appropriating water rights. So I could appropriate a water from a stream that was far away, dig a ditch, and bring it to my 120-acre homestead and cultivate it so I could get my patent from the government land office. Another kind of unintended consequence is it gave the states or the territories the authority to administer and appropriate water rights. Unlike physical land property rights, which were still administered by the federal government, the GLO, Government Land Office, now the BLM, where you had to go get patents from the federal government, water rights were now given to the states and to the territories, which is a pretty significant feature. In 1880, they didn't have much luck, obviously, getting the courts to issue water rights. Again, courts don't work in that way. Usually courts are adversarial proceedings. You need a plaintiff and a defendant. The judge just isn't going out there appropriating water rights. So as a result, they said, well, what we're going to do is we're going to set up these county selectmen, and they're going to be these ex officio water commissioners, and they're going to give rights. This was, again, largely ignored. You can see some of these certificates issued by the selectmen in Salt Lake County we've come across. There may be some in Utah County, but I know in Salt Lake County we've seen a few, and they're actually kind of cool records because they document some of the uses that were going on at the time, which we just don't have records of. But again, ignored, and I think it was even decided to be unconstitutional because you had an executive officer giving property rights, which is kind of the purview of the court. There's some strange legal reason why it was thrown out. Well, as a result, confusion continued to exist in spite of the best efforts of the Territorial Legislative Assembly or the LDS Church. And the church continued to administer and decree water rights. An example that I always cite in this meeting is the 1879 High Council decision that divided the waters of the Spanish Fork River, which to this day, that's still how they are divided, based on the High Council decision. Now, there's been subsequent decrees that have confirmed that, but the same large irrigation companies get the same amount of water that they did under that decision. So we move into statehood, 1896. And there was a lot of, when you become a state, suddenly you've got to create a code of a book of laws. You've got to create a constitution. And, there were some ideas floating around that how do we do water rights? Again, the states had been delegated the authority to control water rights. And so there were some notions that, hey, what we should do is just confiscate all water rights and the state owns the water, and then we'll issue them back out. And obviously that sparked a lot of contention. People didn't like that idea very much. And so out of fears of doing anything, they just decided, hey, we aren't even going to touch that with a 10-foot pole, but here's what we're going to do. In the state's constitution, we're going to have a clause that explicitly says if you have water rights, you can continue to use them. Or if you've been using water, you can continue to use them. That's actually Article 17 of the Utah State Constitution. It's still in there. It says, all existing rights to the use of any of the waters in this state for any useful or beneficial purpose are hereby recognized and confirmed. So it's kind of like grandfathering people in. If they'd been using waters prior to 1896, they could continue to do so. Today we sometimes refer to those as diligent rights, diligence claims, pre-statutory rights. Those are a bunch of different names for kind of the same thing. Well, in 1897, the Office of the State Engineer was formed, and that's what we now know as the Division of Water Rights. So my boss, Kent Jones, he's the state engineer. It's kind of a historical title more than it is really a title of prominence because there are plenty of engineers that work for the state of Utah. But we're essentially known as the state engineer's office. But he was tasked with the creation of the office. He was tasked with creating hydrographic survey maps, essentially figuring out where all the streams were in Utah and what their capacities were. To get a water right, you still had to appropriate the old-fashioned way, like an old mining claim. You had to go stake your claim at the point of diversion and then go file it with the post office or the county recorder. And again, those were largely ignored. People continued to kind of do what they wanted to do. Well, that was until 1902, the United States Reclamation Service was created. That's what we now know as the Bureau of Reclamation. And their mission was to go out and reclaim the arid West. And they do that by going and building huge dams across rivers that would make big reservoirs. And the whole purpose of those reservoirs were to create enough water to irrigate more cropland, especially during the winter months. But the the Reclamation Service at the time, now the Bureau of Reclamation, was really worried that if they were going to go into any state, they refused to do any big projects until that state had some type of system down that would both define the existing rights but also appropriate new water rights. And so the state of Utah didn't have that at the time. So it's no coincidence that in 1903, Utah finally came around and said, okay, we want the Bureau to come in. We want them to build projects in our great state to help our farmer irrigate. So we are going to codify water law. We're going to have a law for recording all the existing rights, as well as a law to appropriate new water rights. Unfortunately, the legislature failed to provide any funding, and it was really, again, given the courts the responsibility, hey, the legislature pretty much punted and said, all right, courts, you figure out the existing rights. But again, that's not how courts work. Judges don't go around looking for problems to solve, right? They wait for problems to come to them, and then they settle matters between two adversarial opponents. So it never really worked out to determine all these existing rights, but they wanted to start appropriating new water rights through the state engineer's office. And that was only for surface waters. So in 1919, the state engineer, recognizing that, hey, we're not getting around, we're not figuring out all of these grandfathered rights. Just because the courts aren't doing what they're supposed to be doing, because that's not what they do, and the legislature never gave them the money to do that. So in 1919, the legislature finally fixed the statute and said, all right, what we're going to do, instead of the courts having to go out and find this stuff out and figure it out, we're going to have the state engineer go out, map things, map irrigation, map water use, and take claims, and then deliver what he thinks the recommendation should be to the court. And then he initiates a civil procedure, and then the court rules on that recommendation. And that recommendation is what we call the proposed determination of water rights. Sometimes we just call it proposed determination. And that's largely the system we have today, where the state engineer is responsible for taking claims, making a recommendation to the court, and then the court makes a decision on what these existing rights should look like. All right. You remember in 1903, it was only for surface waters. Well, they finally figured out that, hey, groundwater is the same as the surface water. It's just coming from a different place. So prior to 1903, you didn't really need a water right to divert water from a stream or any type of surface waters. After 1903, if you wanted to start diverting water, you had to get a water right through appropriation with the state engineer's office. Well, in 1935, it's the same thing except for groundwater. Prior to 1935, you could have a well drilled without needing a water right. And so a lot of those were drilled, especially in urban areas like Provo and downtown Salt Lake. And that's how the residences or the houses supplied their water with culinary water. They just punched a hole in the ground. A lot of these had artesian flow pressure, and they would just take the water, because it's free water coming up through the ground. So we have a lot of those types of rights that were established prior to 1935 for wells. After 1935, if you wanted to drill a well, you had to appropriate a water right similar to how you would for a surface water right. So the historical case for adjudication. Prior to that 1903 enactment, water law, water rights are kind of found in a couple different categories. First are those rights that are kind of decreed by ecclesiastical leaders, right? The bishops' courts and the stake high councils. You had those that were filed for record at the county. Remember that the county selectmen would come out and issue a certificate, or they would go and stake a claim and then go file it at the county. Again, there was no rhyme or reason as to how the county usually put those in their records, so they're really hard to locate. You had those rights that were decreed by a court, and again, those were typically limited to different parties, to individual parties. So if you had Party A and Party B, and they didn't like each other on the same creek, and one wanted to divert over the other, they'd go and sue each other, and the court would decide the case with regard to Party A and Party B, but they ignored Party C down here. So the court didn't decide these rights as to how they relate to Party C. So there was kind of a limitation on how effective those court cases were. Then you had contracts and agreements that were just done unilaterally, usually among municipalities or irrigation companies. They'd say, hey, a classic examples in Salt Lake Valley where Salt Lake City contracted with people who had diverted out of the canyons to get that clean canyon water, and then they would make them whole with water from the Jordan River via Utah Lake, or Utah Lake via the Jordan River for irrigation. And they say, you give us the clean water, and we'll provide you a constant supply of Jordan River water to irrigate. It's just as good to irrigate, it's just not as good to drink, but we need the clean water so we can treat it and provide it as culinary source for the city residents. And then you had those claims that just never manifested themselves on any records whatsoever. And these are those old diligence claims that we're talking about. So prior to 1903 for surface rights, prior to 1935 for underground rights. These are people who have a right, they continue to have a right, and had no real reason to bring those rights forward to be recorded, but they continue to use them. We see a lot of those as far as wells in these types of areas. Sometimes in the canyons, up in the further flung areas, you can have some surface rights that still haven't been brought onto the record, but these are those pre-statutory rights, those diligence claims. Well, as a result of this, there's a number of issues, okay? First, there was no public record of all the water rights. There certainly wasn't a consolidated public record. You might be able to find records here and there in different county recorder's offices or on the court docket, but you couldn't go to some place and say, I want to know what the rights are on this particular river in this part of Utah, okay? Because there was no public record, over-appropriation was pretty rampant. There's a lot of cases, incidents where the court decreed a lot more water, or kind of divided more water up amongst the parties than ever existed in the stream in the first place. And then you had just a lot of confusion, so people assumed that they had the same amount of water as this person. But if they're both taken, there's more appropriation than there was actual wet water. And as a matter of fact, we still have that problem today. We have more paper water than we do wet water. Because rights weren't defined, they became in controversy. They had to be settled through ecclesiastical or court decree. So back in the early 20th century, the state engineer was obligated to file a biennial report. And so in his 1901, 1902 biennial report, you remember this is right before they came up with this idea of comprehensive water license. Hey, there's some critical things that need to get done. This is what he said. He said, the definition of existing rights appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before the existing rights are known and made a public record. So the whole idea was, before we appropriate any new water rights, we are going to figure out what water rights are already existing. But as I already mentioned, the system they set up to do that failed miserably, and they got impatient. And so they decided, what we're going to do, we're just going to appropriate new water rights. We'll catch up figuring out the existing water rights. We'll do these in two parallel processes. Which brings us to the general stream adjudication, or the general adjudication, water rights adjudication. What is it? Well, first of all, it's an action in state district court. As the name implies, it's a legal proceeding, adjudication. It binds all water users and the state engineer. So rather than just kind of doing onesie-twosies, it binds all of us together, okay, in one civil proceeding. That's the title of statutes governed by Title 73, Chapter 4. The first general adjudications took place back in the 20s. You remember that we didn't get the mechanism for doing adjudication. That proposed determination concept didn't arrive until 1919, if you remember the slide, if you slide back. So they didn't really do anything until the 1920s. And if you look at the slide, you see all those colorful little patches all over the state of Utah. Each of those represents a different general adjudication, okay? And so, and I forgot to mention, this slide deck as well as the recording will be available on our website tomorrow. So you're welcome to take whatever photos you want, or you could just wait and download the whole thing tomorrow as well and flip through it at your leisure then. When we talk about the Provo City South adjudication, or the subdivision, we're really talking about the Utah Lake Jordan River general adjudication, that big purple blotch. And you can see it's actually pretty large. It covers Salt Lake Valley, all of Utah Valley, up into Heber, right? So everything that drains ultimately to the Jordan River is covered by this general adjudication. So the Provo City South is just one bite-sized piece of this big purple monster that we're looking at, right? It's hard to see, but it shows the dates when all of these commenced. A lot of them commenced in the 20s and were actually finished, like the Sevier and the Weber and even the Virgin River. The Utah Lake Jordan River general adjudication actually started in 1936. At that time, there was a huge drought going on throughout the nation. You recall, we're in the midst of the Great Depression, the whole Dust Bowl, the Okies migrating to California. Well, because there was a huge drought, a lot of people were throwing their own pumps into the Jordan River, and Salt Lake City said, hey, you can't do that. And so Salt Lake City, in essence, tried to sue like 1,000 individual people. And the court said, well, hold on, Salt Lake City, we have a mechanism to do this called a general adjudication. So at that time, the court turned that civil case into a general adjudication. And recognizing that there are other second and third order effects upstream of the Jordan River, they built this larger case. And so this case, this proceeding that we are currently undertaking, has been going on since 1936, if you can believe it. It's actually, from what I understand, the oldest civil proceeding in the state of Utah. As a matter of fact, if you look at the civil numbers for the court cases, it has a 3-6 in front of it because that's the year it was started. And when we started doing this again and started actively talking with the court, they're like, oh, that can't be the right civil number. That's in the future sometime. And they're like, no, it's 1936, not 2036. And so it's been a long proceeding. The state of Utah has been pursuing it in kind of fits and spurts. In the last 10 years, we've kind of decided, hey, we just need to get this done. We need to get it over with. And so we've kind of done the west side of the valley was done back in the 80s and 70s. The last 10 years, we've recently done the east side of the valley. And so now we're kind of migrating south into what we call the Provo River Division. And so Provo City South is kind of on the south end of the Provo River Division. And then we're going to migrate north and kind of move up the Provo River. So I get asked a lot, why are you guys doing this to us right now? What's your ulterior motive? How does this, because usually there's some like Walmart going up or some mall going up, and they always assume that we're in cahoots with this private developer of some sort. But in fact, it's just we're finally here. It's been since 1936, we finally got around to your neck of the woods, for better or for worse, I guess. So why do we conduct general adjudications? First of all, we want to bring all claims onto the permanent record. You remember this guy? He's the guy using his water, has no care in the world, doesn't want to bring it onto the division's records. Well, the adjudication requires those individuals who have these types of water rights, these grandfathered rights. Again, we call them diligence claims. Usually is what we call surface rights, and we call underground water claims for underground water rights. Part of the process requires them to bring that claim onto the record, okay? We also have these things called Federal Reserve water rights, and this has nothing to do with the Federal Reserve that prints money. It's really a concept that grew out of a Supreme Court decision back in the early 20th century. There was the Fort Belknap Indian Reservation up in Montana off of the Milk River, and you'll recall the whole reason for these Native American reservations was to kind of have Native Americans become agriculturally based and kind of turn them into what our idea of people should be, which was agrarian, right? And they were trying to do this, and they went to the equivalent of the state engineer in Montana, and they said, hey, we need some water from the Milk River if you guys want us to be agrarian. If you really want us to cultivate fields and those types of things. We need some water. And the state engineer said, gee, I wish I could help you out, but it's fully appropriated. All the settlers around you have already appropriated all the waters of the Milk River. You can imagine that didn't sit very well with the Indian tribe. They didn't think it was fair that they were relegated to that reservation and then told to do something and then withheld the means to accomplish that. And so they took the state engineer to court and ended up in the Supreme Court. And the Supreme Court made the ruling that because the federal government had reserved that land, that they had also reserved, by implication, a water right for the purposes of that reservation. So in this case, the purposes was for the Indian tribe, and so the federal government, or the Supreme Court, said there's a water right equal to the priority date of the water right is equal to the reservation when it was established, okay? Now you might say, well, what does it have to do with Utah? Well, in Utah, we do have some federal, we do have Indian reservations. We have Navajo, we have Ute, and we have Shivwits. We have actually quite a few, if you can believe it or not. But more importantly, we also have other types of federal reservations, because this concept, we call it the Winters Doctrine, has been applied to other types of federal reservations. You can think of national parks, those are federal reservations. National forests are federal reservations. Mount Timpanogos, what is that? The monument, I think is a federal reservation. So all of these reservations have implied water rights. The problem is you can't sue the federal government without the federal government giving you permission to sue them, right? So if you wanted to say, all right, federal government, we think you claim a water right for the, let's just say, Forest Service, right? So this is all Forest Service up here, right? So because that's been taken out of the federal reservation, the Forest Service claims a lot of rights, a lot of water rights. But they could never be forced to say what those claims are or to quantify them. They could say, we don't have to do anything. We're the federal government. You can't say it. Well, there was a senator from Nevada, Senator McCarran, who said, well, that's just not fair. You know, the western states are trying to do their best to settle what their water rights are, to get an idea so that they can plan for their future. And it's not fair that the federal government can just kind of hold them hostage with these unquantified claims. So he passed the McCarran Amendment, which in essence said not only can the states sue the federal government, but they also, so essentially the federal government waives their federal sovereign immunity. So the states can sue the federal government to force them to quantify their water rights, but they also have to do it in state district court. So that's one of the few instances I know of where the federal government has to show up in a state district court and defend its rights. And so that's one advantage of a general adjudication, is it kind of forces the federal government to come to the table and negotiate so that we know really what those claims are and what they claim a right to. Another thing we want to do is we want to prevent a multiplicity of suits. We don't want everyone suing each other because everyone thinks they have senior priority. We just kind of want to get it all in one big group and pull the Band-Aid off once rather than multiple times, right? Okay, so here's probably the more controversial part of a general adjudication. It's really a concept that is part of most Western states' water laws. It's this concept of use it or lose it. You can imagine that in the state of Utah, Wyoming, Montana, these arid western states, that the demand for water is larger than the actual amount of wet water, right? And so when the first Utah legislature was drafting their concept of water law, as well as other states, they kind of adopted some of the things from Wyoming and Colorado and Oregon. And one of those was, hey, you have to use your water, otherwise you risk abandoning it. Because if you're not going to use your water, someone else will, okay? And so that's one of the aspects of the general adjudication is we'd come out and we say, all right, there was once a pasture here for 40 acres. It is now a Walmart parking lot. There is no irrigation going on. This water right that once irrigated this is no longer in use. It's been abandoned or forfeited. And then we make that recommendation to the court. So part of our process is to kind of weed out water rights that have not been used. So in Utah, if you haven't used your water right for a period of 7 years or more, it may be subject to forfeiture, okay? And so it's important, and I'm going to kind of I don't know if any of you have been in the military or anything, but we usually when like an important concept comes by and you have an instructor, they usually stomp their feet and tell you. So it's important when you guys file a claim and we come out to evaluate that claim that you're using the water, okay? Because if we come out and we see you guys using the water, we're not going to investigate further. We just say, great, they're using their water. Let's drive on and move on. So we want people to use their water rights. But if the water right hasn't been used for a period of 7 years or more, then we have to make a recommendation to the court that it be forfeited, okay? And that's kind of the most controversial aspect of this process. But I want to kind of give you the flip side of the coin so you understand why that's necessary. Let's say you are a water right holder and you have a priority date that's pretty senior, but there's someone who has a water right on the Provo River that's more senior than yours. But they decide not to use their water for a period of 50 years. So suddenly they're not using their water, which means you get your water right. You get your water, that wet water. And you've suddenly, over the last 50 years, you've developed houses. You've built houses, or you've developed your farm, and you've put it to use, and you've become reliant on that water. And then suddenly, 50 years down the road, this individual decides to say, nope, I want to use my water again, and you're suddenly cut off. So you can see that was really the intention that the founders of our state tried to write in. They were worried about monopolies, grabbing all the water and then forcing people to pay outrageous prices, as well as people becoming reliant on water that suddenly gets pulled out from underneath their feet. So that's the reason why we try to look for water rights that have not been used and just get them off the records. We don't want them as a state just because we don't want to plan on stuff that's not being actually used, all right? Lastly, we want to obtain a final comprehensive decree on all the water rights. And so as a part of this, we'll make a recommendation to the court, and then the court will issue a decree, and suddenly your water right that was once a certificated right or an application to appropriate or a diligence claim now becomes a decreed right, which is kind of the gold standard of water rights, where the previous rights were simply prima facie evidence of a right, meaning it appears that you have a right, now you have a decreed right, and you have an actual bona fide right. So that's kind of the gold standard of why, what the ultimate outcome of this process is. So let's talk about the process. I'm going to move through this slide pretty quick. Just know that I'm going to dive into details on the important things in the subsequent slides, all right? So it's kind of a three-phase process. The first phase culminates with what we're doing today. Step number 4, the public meeting, all right? The petition was actually, back in 1936, the court ordered an adjudication. The notice, we published notice in the I want to say the Daily Herald of the initiation. We've sent summons, and we're also publishing summons. So that's step number 3. That's a requirement we have to do. Because it's a legal proceeding, we're obligated to send summons. We try to soften it as much up as possible. We even put freaking cartoons in there just to kind of ease people into it. But I understand you get to that summons and you forget everything else that was in that letter, and I totally understand. Unfortunately, that's just one of the requirements we have to do. The next step, and again, I'm going to get into this in more detail, we're going to send out notice to file claims. If you have a water right you want to file a claim on, you'll simply fill out the form and you'll mail it to us, or you can file it with the district court. For rights that we have a record of, and these are water rights that we have a whole big file room back in Salt Lake City, and they represent all of the water rights of record in the state of Utah. So those are water rights that have been appropriated. They're water rights where people have filed a diligence claim and brought them onto the record. If we don't receive a claim for those water rights, they get put on this list of unclaimed rights, okay? And then we send out notice and public meeting. And if no one claims those rights, then the court says, all right, no one has claimed these rights. We're going to assume that they've been abandoned. And the court says, these rights on this list are now abandoned. And we move on to the next phase of the process, which is kind of the claim investigation. So if you did file a claim, We're going to send someone out to meet with you, look at your well, your head gate, see your beneficial use, and make a recommendation. And we'll send you a copy of the recommendation. But that recommendation ultimately gets compiled into what we call the proposed determination. We file that with the court. We give everyone an opportunity to object to that, saying, well, no, the state engineer got it wrong. This is what's wrong. We hold another public meeting like this. Usually about 5 people attend it. And then we hopefully ultimately get a decree on that proposed determination, decreeing those rights as valid. So let's kind of dig in. Your next step is going to be filing your water user's claim. John, what's the date we have that we're going to send the notice out? I forget. August 2nd, thank you. So on August 2nd, we're going to mail. You probably won't receive it on August 2nd. That's just the date we're actually going to mail it out. We'll send out, if you receive the notice tonight, you'll receive a notice to file claims, all right? In that notice, there will be a claim form. If you are a water right owner of record, meaning that you have a water right on our records and your address is correct on our records, you'll receive a claim form that's already filled out. All you need to do is sign your name and return it to us. You can even scan it and email it to us, and we'll consider that good enough. If you're simply a property owner, now we sent out like 12,000 notices, okay, because that's how many property owners were in this little piece of this subdivision. And we wanted to cover everyone. So maybe there are certain people that probably got more than one notice because they may have more than one property holding. We tried to ferret out the duplicates. Sometimes we don't do a good job. But in any case, you'll get a blank claim form. It takes a little bit more understanding how to fill it out. And so we encourage you to call us up or come into our office, and we will help you fill that claim form out. If, in fact, you do have a water right. Let's say you have a well on your property that's not documented as far as we can tell, we'll help you fill that claim out. It can be kind of tricky, unless you know what you're talking about. It's not intuitive, but it's the form where we were given, and it's kind of the format that the statute requires. Once you receive that notice to file claims, you have 90 days to file your claim. So you have 3 months in essence, but exactly 90 days from the date the notice was mailed out. I think that is around October 31st. I have a slide on here that has the timelines. I believe 90 days from August 2nd gets us to October 31st. I could be wrong on that. But in any case, 90 days to file a claim. If you need just a little bit more time, you can simply email me a request for an extension, but it has to be emailed to me within that 90-day period, and you're automatically given an additional 30 days. Once we receive your claim, hopefully you'll put your phone number or your email address. We'll attempt to make contact with you and schedule an appointment for us to show up, and you can show us your well, your sprinklers, whatever. We find that investigating these claims are a lot easier if the actual water user is there to help us navigate and understand the use that they're claiming. If you don't file a claim within 90 days and you're a water right owner of record, that right goes on the list of unclaimed rights, okay? And so again, we have all these rights. In this area, we have 652 rights of record. Now, that means there could be rights that we don't know of, those old diligence claims, but these are the ones we have record of. And so let's say you are an owner of one of those rights and you fail to file a claim within that 90 days. It will go on this list. And then we'll send notice of this list to the same people who received notice of this meeting tonight. And we'll hold a public meeting. And you have 90 days from receiving that notice if you want to claim that right. So if your name shows up or if your water right shows up on that list and you don't want it to be there, you have 90 days to file an objection and a water user's claim. Now, since we're now into the legal proceeding, you actually have to file that objection with the court, third district court. But the instructions are in the list of unclaimed rights, okay? If you need more help in understanding where to file that, contact our office and we'll help you. Again, we're not in the business of abandoning water rights. If you have a valid water right and you simply just, hey, it got away from you, life's busy, I get it. We're here to kind of help you. We can't give you legal advice, we're not attorneys, but we can kind of get you pointed in the right direction. And for the most part, people who try to do this on their own. If we give them some direction, don't really have a problem in getting it where it needs to go. But you got to file that objection within 90 days of receiving notice of the list of unclaimed rights. I put this part in here. We can negotiate and settle, but usually what we do is we just say, yep, we don't agree, we don't disagree. We tell the court to simply allow the claim to be taken off the list of unclaimed rights so you can claim it. Again, we're not in the business of trying to keep people from preserving their water rights. As I mentioned before, once we've resolved all the objections, the court will issue a decree that says those water rights are now considered abandoned. They don't go anywhere. They just become no longer valid for use. We don't sell them. We don't pocket them. No one can get them. I mean, I guess someone could buy them from you, but it'd be worthless, right? And also at that time, the court will close that area to any new diligence claims, or a pre-statutory claim. So if you're that guy who just hasn't filed a claim on a pre-statutory right, your time to file that claim concludes with this process, all right? And you can no longer do it in the future. So it's really important that they participate in this process, which is why we send it to all property owners, just to make sure we can capture them. Okay, proposed determination. Again, this is, in essence, the state engineer's official recommendation to the court as what he thinks the water rights should look like. We take all the claims, we make our recommendations, we send those recommendations to the individual claimants, just say, hey, this is what we're thinking, let us know if we're wrong, and then if we don't hear anything, we'll compile them into a proposed determination. We'll send notice, but this notice will only go to those who have filed a claim. So if you were among the 12,000 property owners and you didn't file a claim, you won't receive notice of this because we'll assume you didn't file a claim, you have no interest in the proceedings anymore. If you are still interested, let me know and we'll keep you on the list. So this, in essence, shows what we've investigated in our recommendation to the court. We'll hold another public meeting like this, again, not highly attended. Similar to the list of unclaimed rights, if we get something wrong in our recommendation to the court, you have the opportunity to object. You file that objection with the court. There's no real standard format. There's always a legal, template that attorneys use. But if you're a pro se litigant, meaning it's just you and you're representing yourself, writing a letter to the court is just fine. Just say, hey, I object to this proposed determination. They got this wrong. Just do it in narrative format. We'll figure out the issues later. You just got to get it in. When we get an objection, we are obligated to resolve that objection before we can petition the court to decree the proposed determination. So if you file an objection, we'll get in contact with you. Actually, the special master who's been appointed, he's kind of like a mini judge that presides over objections. We'll kind of shepherd this objection through the court process. But usually what we end up doing is meeting with the person who objects. If we made a mistake, we'll admit it and we'll change it and we'll drive on. It won't be a big deal. If we don't agree with you, we may choose to litigate it. So, we aren't going to roll over on things that are just obvious. But if it's something that is, not obvious and we just missed it or whatever, we're happy to work with a water user to make sure they get the full benefit of the doubt. And then once all those objections are resolved, we get a judicial decree that affirms the proposed determination with any modifications made during the objection resolution process. So here's what the Provo City South Subdivision looks like, kind of like a knife digging into Utah Lake. We don't get a lot of water users claims out in Utah Lake, but it kind of looks like we got a couple floating points of diversion. That's why we take it all the way out in Utah Lake. Sometimes we catch stuff that shouldn't be there. All of those pink dots are points of diversion for water rights in this subdivision. I think they have about 652. Again, most of them are underground wells. There may be, I know that there are water rights that are diverted from Provo River and shepherded down via canals and ditches. Those will be addressed in a later subdivision. It's going to be the Provo City North subdivision, where we'll catch those points of diversion. So the way we do this is we just get a big area and we say, all right, if you have a point of diversion in this area, these are the rights we're going to look at. So even though you might be using water that was been diverted from the Provo River way up there, up north, you probably won't be looked at until we get to that area, which is in August, is when we're going to initiate that. But usually those are canal companies that have water rights coming off of the Provo and ferrying them down and ferrying them all the way down here. Okay, here's the issues and anticipated timeline. Out-of-date title, the water rights on the state engineer's records. So when a person buys a property and it has a water right on it, they go through the title update process with the county recorder's office. So they become owner of that property and probably owner of the water right on the property. The problem is our records are different than the county recorder's records. And so the county recorder doesn't know to say, hey, this water right's part of this property. State engineer, update your records to reflect the new ownership. So what can happen is people will buy and sell this property, and the person who originally appropriated the water right, who we show as the owner of record, is now different than the property owner or the contemporary property owner. And so we'll send notices to the water right owner of record, and it might be like some P.O. box that doesn't even exist anymore, as well as the property owner. So if you feel like you have an issue where our records don't reflect your ownership, there is a process to resolve that. It's called the report of conveyance. But that can be done separately. We encourage people to do that, but it's not required as part of this process. The most important thing is you file a claim, and then we'll figure out what water right is associated with that claim if need be, and then you can update title to that at a later time if you so wish. But we do encourage people to do that. Location of no proof required water rights, or NPRs. These are water rights where that were usually appropriated back in the 40s. There were a lot of, at that time, we were fighting World War II. The individuals who, so kind of back up, when you file a water right application and you're given an application, you're required to file proof on it some 5 years later to show that you're actually beneficially using it. But to file proof on it usually requires a surveyor or an engineer or an attorney, or as a survey engineer, to file a proof on this water right. Well, in the 40s, a lot of our surveyors and engineers were fighting Hitler and the Japanese in the Pacific during World War II. And so the legislature came up with a law that said, hey, if it's a small amount of water, we're just not going to require proof. And it was great, right? It helped out a lot of people for small amounts of water for like their culinary connections and those types of things. The problem is that when people applied for those water rights, they tried to do their best at locating where the water rights, where the points of diversion were, but because they didn't have a proof engineer or a surveyor come and actually map the exact location, where we show that point of diversion may not entirely be accurate. Our record of it may not be correct just because we never got an actual proof map of it, okay? So you have to take with a grain of salt. I'm going to show you an interface after we're done here that shows our map. We have a digital aerial imagery interface that you can it's an interactive, you can kind of zoom in and out and see if there's a well on your property that we have on our records. You just got to take those locations with a little bit of a grain of salt, depending on how they were located and how the county surveyor monumented the section corners and how the GIS guy correlated the aerial imagery to the PLS system. There's a lot of factors go into it. Bottom line is, if you see a point of diversion in the middle of your house, but it's actually in the back of your yard, but it looks like it's on the middle of the house, that's just an error. We'll correct it during this process, though. Okay, anticipated timeline, August 2nd, that's when we're going to send the notice to file claims. October 31st, that's when the 90-day claim filing period expires. We're going to begin investigating the claims we get that are filed. Around February 2020, we aim to publish the list of unclaimed rights. 90 days later, May 2020, is when the opportunity to object to the list of unclaimed rights concludes. And then in August 2021 is when we're looking to publish the actual proposed determination. These are big processes, some of the water rights are complicated, so it takes us a lot of time to actually process the water rights. Plus, we're doing other areas as we do this, and I have a limited staff for a statewide program, so it takes some time. Again, you'll have a 90-day objection period, which if we publish in August of 2021, would expire in November 2021, okay? Biggest questions I usually get, will I lose my water right? Water users who are currently using their water rights in conformance with the records on the file, Division of Water Rights, have nothing to worry about as long as they file their claim. If you're using water without a water right of record, you are required to file a claim, otherwise you're going to risk never being able to do this in the future. So now's your chance to file that claim. And if water use is not, if the water right has not been used for a period of 7 years or more, it may be subject to being disallowed. So the state engineer would recommend to the court that it be disallowed or forfeited, and the court may issue a decree saying that whole water right or a portion of the water right is no longer valid. Who can I contact? That's me at the top. Gary Brimley, who's kind of my deputy, is not here tonight. But John Breen, he is going to be the team leader directing the boots on the ground efforts in this area. So when a claim is investigated, it's going to be one of his team. John, where are you at? He's back in the back, with his hand up. You meet him later. I also have various other staff members here that can answer questions. I think we have some maps up in the hallway or back, where the maps get put. They're out in the hallway. So I have some big maps of this area that you can go and look and see if there's a well that show the point of diversion in a blown up aerial imagery. But if you have questions, free to ask my staff. I'm happy to answer any questions right now. I'm going to check my email, see if anyone's emailed any questions in. So let me do that quick, and if no one has, then I'll take some questions from the crowd. It doesn't look like anyone's emailed any questions in. What questions do you have? Yes, ma'am. Yeah. 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 Sorry. Yeah. Sorry. She's asking about. She's asking a question. Is it true that it's May 20 and then August 2021? And that's not a typo. Yeah. It takes a year. Part of this has to do with a settlement that we had with Central Utah Water Conservancy District, Salt Lake City, and some other big water users. They didn't want us. They want us to do all of the subdivisions up to Heber and then publish them at the same time. So that's why it's delayed a little bit. Okay. Hopefully it doesn't take us that long to do this subdivision, but we're just going to delay it so we can publish them all at the same time. Yes, ma'am.
So I'm a little embarrassed to ask this question, but I'm going to ask it anyway.
Shoot away.
So I have a well, but it's gone dry. So would it ever get water in it again?
So her question is, she has a well, but it's gone dry, and her question is, will it ever get water in it again? So a lot of these wells, as I talked about before, were just holes punched in the ground, and they relied on the pressure, the natural artesian pressure for water to bubble up and use. Well, as the area is developed, cities have sunk big wells, agriculture, farmers have dug wells, and so the water table has subsided. As a result of that, a lot of these artesian wells don't get water naturally flowing up. The case law, so this was a law something that taken to the Supreme Court, Utah Supreme Court, saying, well, hey, people have impaired me by lowering the water table. I'm not able to get water anymore out of my well. And the Supreme Court actually ruled that it's up to the water user to chase the water. The water's down there. If you wanted to get it, you have to put a pump in. If it drops below the pump, you got to sink your pump lower. And I know that doesn't seem fair. That's the Supreme Court's ruling. And so if you were to, the rule is the water's there, you just got to chase it in a well. Yes, sir.
Could you elaborate on the no proof required water rights?
Sure. He's asking me to elaborate on the no proof required water rights. Did you have anything in particular you had a question about? I did cover it. So these are the water rights. where there were no surveyors or engineers to file proof on them because they're all fighting Nazis and Japanese, right? They didn't have enough around for people to file proof. And so the legislature said, hey, we're not going to require proof. And so really the problem with that is when they applied for a water right, they may have said, I want my well right there, and that's where I'm going to file my application. And the well driller comes out and it's like, it's a crummy place. I got my witching sticks. I'm going to figure out, yeah, it's better over here. Let's just drill over here. So they drill it over here. And so in a normal appropriations process, you'd have the proof engineer come out, survey in the location of where the well was actually drilled, and then report that back to the state engineer. However, that never happened on no proofs required. And so our records still show the well over here, even though it's actually over here. So when we look at, let me just bring up what I was talking about, our interface. We bring up this map, and I'll zoom in to, I'm going to turn something off, really. Let's just zoom into Provo here. Here's area 55-6, right? It's magic. And if we zoom in, and I'll turn the points of diversion back on, you'll see a bunch of cluster of red dots. So these are all the wells that we have. The red are wells, the blue are surface diversions, you can see up there. But if you zoom in on some of these, you might say, well, is in fact that well right there, or is it maybe over here? So that's what that's the problem with no proofs required, is that the location of the wells may not be close to where they're shown on this interface or where we have records of them. But that may be also associated with any water right, just because the description by the surveyor to the location of the well is affected by where the county surveyor locates the section corner. So if you're a surveyor, you know exactly what I'm talking about, or you have experience. If you're not, just take my word for it. Things get jacked up, all right? So just don't take these points of diversion for granted. Just if they're close, that may be more accurate. It's not going to be exact. Yes?
If you don't have a well on your property as of yet, but you want to claim one in the future, can you do it within this window?
That's a great question. So the question was, if you don't have a well on your property now, but in the future you want to have a well, it's a good handy thing to have. Can you do that as part of this process? The answer is no. This isn't for claiming new water rights. This is for claiming existing water rights. If you want a well, there is a way to do that. You'd have to, this area is closed to new appropriations because we pretty much have twice as much paper water as we do actual wet water, meaning we have more water rights than we have physical wet water. And so a long time ago, state engineer closed this area to any new appropriations. But you can still acquire a water right from somebody. Let's say you're one of these houses and you say, I want to buy your water. You just go down the street, you find the owner, say, hey, I want to buy your water right. You buy that water right, and then you file a change application to get a well drilled in your yard using that water right. I caution you from buying a water right that has not been used in the last 7 years, because you may have a problem. It may just get turned into nothing through this process. So you can buy water rights. You can go on KSL. You can buy them. There's like a waterrightsexchange.com or Utah waterrightsexchange.com where they barter in water rights, but you just have to find them. Yes?
All right, now, so I understand many of us own shares in a water company.
Uh-huh.
I assume then that it's not our individual responsibility to file, it's our company's.
Yeah.
Our responsibility is to make sure that the company does the filing.
Yes, let me just repeat that for everyone's benefit. But yeah, you're exactly right. So or you say, hey, I'm a shareholder in a water company. It's my understanding that it's the water company's responsibility to file a claim. And us as shareholders, our responsibility is to help encourage the company to do so, or maybe the board, or maybe you're a member of the board. Yeah, exactly. You want to encourage the water company to file a claim. Depending on where their water rights originate, if they originate from the Provo River, it may not be time for them to file a claim. It might be in the next subdivision when we get up there into the Provo City North area, when we abut the Provo River. But if they have like water rights out of a well with a point of diversion, then it would be time for them to file a claim. But they can file a claim anytime, as long as they do it within that 90-day time period. But if they want to do it earlier, they can do that too. Yes, sir.
There's an existing Morse decree on the Provo
That's a great question. So this question is with regard to the existing decree on the Provo River, as often referred to as the Morse Decree. And how does that play into this general adjudication concept? So the Morse Decree was amongst limited parties, but it did distribute the Provo River, and it had some interesting features to it, in that it allowed junior diverters up in Heber City to divert prior to the senior rights on the lower Provo. And there's lots of different interesting features. The bottom line is, when we go through and we adjudicate those rights, that Morse Decree gets subsumed into this general adjudication, okay? So what we try to do is we try to replicate what the Morse Decree already articulates, and we try to do that so there's not any disruption to how those rights are distributed amongst the various class awardees up the Provo River. So, yeah, there's a lot of concern about that with big water users. We do our best to make sure that that doesn't get interrupted. Yes, sir?
After everything's all said and done, at the end of this, who ends up with like an unclaimed rights? Do they just disappear? Or?
Yeah, so his question is at the end of, when all the dust is settled, who ends up with these forfeited rights or the unclaimed rights? Where, does someone get them, or do they just disappear? They just disappear, in figuratively speaking. There are still files on our records, but they're just void. They're of no effect. They're not effective. You can't divert water against them. You have no claim to that water anymore. So they just become useless. They're paper.
You mentioned that if you had a conveyance of property, that you're not sure if the water rights came with it.
Yes.
That's what I'm concerned about. We bought the property from a family member.
Mm-hmm.
The name is on the water right, and grandfathered into that.
Okay, so I'm going to repeat your question for the sake of the audiences of the online viewers. Our question is, I mentioned about title transfers of water rights, and if you've bought the property and you're not sure whether you're now the owner of the water right, even though you are the owner of the property, and how does that work? So to kind of give you some background on how title transfers of water rights correlate or relate to title transfers of ground, okay? So in Utah, if you have, I'm just going to say a 40-acre tract of property, because that's a big tract of irrigation, okay? And you sell that property to somebody, and you convey that property via quitclaim deed or warranty deed or whatever, the state law is that the water goes with the property unless you explicitly withhold that water right. And so if someone sells you land, but in the deed it says accepting water rights such and such, or accepting all water rights, if that language is in there, it's assumed to have been conveyed with the land. So typically, people are owners of the water rights, but our records don't reflect it. And so that's the discontinuity there. That's kind of the problem, right? Is that you're in fact the owners of the water rights, most likely. It's just that our records are not updated to match the county records usually. So, this asserting your claim, yes, so in fact you do need to assert your claim, but that will not update our records. There's a separate process called the report of conveyance process. And why we don't do that is because we're not title experts. So a report of conveyance requires a title expert, whether it be a surveyor, engineer, attorney, or a title official, title professional, to file this report of conveyance. And what they do is they go back and they look for the first person to appropriate that water right. Let's just say John Doe, okay? He appropriated this water right on this ground. And you're Jane Smith some 50 years later. Well, that water right professional, or that title professional, is going to search through all the deeds and provide each chain of title document, each deed, until he can see that your chain of title to the land is the same or uniform as the water right, the name on our files. And then he brings that forward to say, all right, it's obvious that the chain of title to the land is consistent. There's no withholding of water rights. Therefore, the transfer of the water right is confirmed in the present day owner's name. And so that's a separate process. But again, you don't need to do that process to claim a water right. What we'll do is we'll just simply recognize the water right in John Doe's name, and then you can do the report of conveyance later. I just don't want people to get confused to think they've got to do that before they file a claim. Again, I'm going to stomp my feet, right? Old military style. File a claim, right? That's the big takeaway. File a claim. If you have any question, file a claim. All right, we'll figure the other stuff out later, I promise you. You and then you. Go ahead, sir. Yes, please.
Provo, with my irrigation, they said we're not providing irrigation anymore. So whether I had a right or not, I don't get the water. Now, it's been more than 7 years. That pretty much say that I'm going to lose my water rights.
All right, so let me repeat what you said. He said, Provo City, I presume is what you're referring to, provided my irrigation once upon a time, and several years ago, more than 7 years ago, they terminated that service. As a result of that, am I going to lose my water right? So there's a lot to unwrap in there. First, I would question, did you ever have a water right, or was that water right owned by Provo City? And they simply provided water to you. So that would be question number one. So I can't answer that question. It would be hard for me to believe that, I just don't understand. I don't have enough variables to give you a good answer, to be honest with you. But I would doubt that you are the owner of the water right if Provo City had power to terminate delivery of it to you. But it does bring up a good point that I want to touch on. So one thing about public water suppliers, municipalities, right? Like Central Utah Water Conservancy District, Provo City, they have great lobbyists. And so back in 2008, they rewrote the law to say that public water suppliers are immune from forfeiture. So a public water supplier doesn't have to follow the same rules. They don't have to use their water within a 7-year period. They can hold it up in store for future development. And so even though Provo City may not have delivered that water to you, they don't suffer the same effect of having their water rights forfeited. Again, I'm not the architect of that law. As a matter of fact, I think at the time, I did not work for the state engineer's office at that time. I believe he was opposed to that, but that's just the way the legislature decided to write the law, and that is how the law is today. So public water suppliers are not subject to forfeiture. It's kind of the bottom line. Yes, ma'am. Do you have a question? Yes.
Mine was kind of similar as the last two. We bought the property, so I don't know if we got the rights with it too. We got irrigation, we paid our yearly dues, we got the schedule and everything, and we got a letter saying, due to the so-called drought, farmers needed the water more than we did, so now if we file a claim, are we going to be able to find out?
So her question, there's a backstory. She was delivered water. At some point, a drought came upon, and you received a letter from the city or from a company, or? Okay, it was a long time ago. You're not unsure who it was from, and they said, we're going to stop delivering water to you. We're going to deliver it to these other areas that have a more important use. That sounds like a water company or a city owns the water rights and is delivering water to you. Now, if you're paying shares for water not being delivered, that kind of sounds goofy to me. I'm not sure what's going on there, but it sounds like the water right owner is someone else. You don't pay an assessment typically for a water right unless you're part of a distribution system. So if you have a water right, you don't pay the state engineer a yearly fee. It's just you have the right. And so when someone tells me I pay yearly assessments or something to that effect, it usually leads me to believe that they own shares in a company and they're paying against those shares. Ma'am in the blue, did you have a question? Yeah.
I had a question about, like between my neighbors and my property, there was a little brook called,
We'll just call it a stream.
yeah.
Okay.
But, and it was fed by these springs, and it was supposed to go to all the farmers, all the landowners south, on 600 south.
So it sounds like what you're describing is an issue between.
Supposed to go with the landowner, Provo Springs, they're supposed to,
Okay, so is there a question in there somewhere?
yeah, so how do you, why do you do that?
Why did I do what?
Well, how do you fix that?
How do I fix it? I'm not going to fix that. That sounds like that's up to those individual parties.
We had property in San Juan County, so I assume you're doing this.
Hey, Josh, can you close that door for me? I'm having a hard time hearing.
I assume you're doing this for the whole state?
Yeah, in various, yeah, we are doing it for the whole state. In
Land in San Juan County, and, 'cause
Well, let's talk later about your land in San Juan County, okay?
you're not doing that right now?
Maybe. We can talk about it.
Okay.
I think I saw an arm back here, and I'll come back to you, sir. Go ahead. You need to speak up, sorry. I'm hard to hear.
As that dietitian well that went dry, I assumed it was because of the drought. So we would forfeit it if we hadn't been using it and we didn't know we needed to chase it.
So, does it go dry on an annual basis, or does it just go dry and stay dry? Like, did it come back in 2011 or 2017? I would say you'd probably be okay, because what we're going to say is, oh, they used it 2-3 years ago. It's not quite 7 years. Still good to go. But I would encourage you, the way the things are going with groundwater, to chase it. But if you've used it within the last 7 years, we're going to say doesn't meet the forfeiture requirements, has to be not used for the last 7 years. You need to chase it. Yeah, I mean, what would happen is you'd file a claim, and we'd come out and you'd say, well, there's the well. It's been dry the last couple of years, so we haven't been able to use it. But the last time we used it was in 2016 or 17, and our water rights staff would probably say, okay. I mean, we're not going to, again, play CSI water rights and really figure out whether, in fact, you have used. We're not going to be oblivious, but we understand artesian wells are temperamental and get affected by drought. And but I really encourage you to put a pump down there and just make everyone's life easier and show beneficial use and get it going. It doesn't have to be anything extravagant. Go buy a pump from Home Depot. But I know it's time and money and effort, and none of us have enough of any of that, and I get it. But that hopefully that helps you understand the situation. Let me go over. I think this gentleman had a question. I'll hit you.
If we sold part of the ground, would you just take part of the water right away, part of the shares? Would the whole thing go away?
So let's back it up a little bit.
Originally, there was 2 acres and you subdivided, and you still have a half acre and you use it for irrigation on your lawn and stuff like that. So you have 10 shares.
Okay, so let me unwind a little bit, unwrap that just a little bit, okay? So, and just for the benefit of the online audience, you have 2 acres, you sold a bunch of it, you still have a half acre that you continue to irrigate with. What would we evaluate that? We'd probably say the water right that was once 2 acres is now worth whatever's being irrigated, which sounds like it's a half an acre. And you say, well, we take away our shares. Well, shares are a different thing. We're not going to take away shares. We're going to evaluate, if it's a share in a company, we're going to evaluate the company's water right and reduce that company's water right by a commensurate amount. Okay, so it's not shares then. It's a water right.
So the well has a certain amount of water to it.
It's a water right, and so it probably has a certain number of acres of irrigation if that's what it was appropriated for.
Is that what they adjust, or they just say
Yeah.
it's still good? Or?
Yeah, we'd come out and say you're only irrigating half an acre, even though the original appropriation may have been for 2 acres. Your water right, 55 dash whatever number it is, once good for 2 acres is now good for 1/2 of an acre. And so a portion of it would be lost to non-use. Yes, sir.
Gathering from your statement about the abandonment forfeiture, that if someone didn't use their water
Well, so here, I'm not going to, the law is if you haven't used it for 7 years, it's subject to forfeiture. Yeah, so it's hard for me because because words have meaning, right? And I kind of sense the legal background here a little bit. So I'm trying to navigate this delicately because my attorney isn't here to kick me in the side. The bottom line is if we come out and the water is being used, we will not really look any further, okay? So if you have a well that's not being used and hasn't been used for a long time, get it back into use before we come out and look at your claim. It's the best advice I can give you, okay? That's one of those hill stompers. Sir?
So say if I was running today, the CUP turns on their pumps on Geneva, and when you come to check, there's no water.
So this question is, say my well's running today, some pumps turn on, drain, and my well no longer is flowing at the time we come in. Usually we can tell if a system's being used recently. It's pretty easy. If it's a pipe, jagged, rusted pipe sticking out of the ground, you say that's the well I use every day. We're going to probably be a little, we're not stupid. I mean, we want to give everyone the benefit of the doubt, but we're not going to perjure ourselves. But we can usually tell, especially if you're using it for irrigation, because we have historic aerial imagery. We can go back and look at aerial images to see if, in fact, that field or that pasture is greened up or not. So we have some tools to kind of reconcile that. Again, we're going to give the benefit of the doubt to the water user. I don't want to make it sound like we're just going to turn a blind eye and you're going to get everything past us that you ever wanted. And, be sensible, and we'll be sensible, and we'll give you as best we can. Again, we're rooting for you to preserve your rights. Just if you kind of get the feeling that you're just kind of trying to pull the wool over our eyes, we might scrutinize a little bit more. So let's just get along, and if we do that, I think everyone will work out where it needs to work out. Any questions? If you want to, I'm just going to. Feel free to leave, no problem, won't hurt my feelbads. I'm just going to show you some features on our interface. If you want to use it from home, it might be helpful. So again, if you come, here's the watch live streaming. I can't stand to watch myself. So if you come to our website, waterrights.utah.gov, and you want to get to that map interface in this right-hand corner right there, you see where my cursor is, you just hit map search, and it'll bring up that map interface, okay? And you can search all over Utah, so if you have property in San Juan County, you can go check that out too. Over here are some layers. Points of diversion, that's the layer that populates with all the wells and everything. I usually turn that off at this level because it just becomes so clustered. Adjudication books, you see where I'm toggling my cursor. That will tell you, these are all the subdivisions that we're currently working in or have worked in. Yours is the 55-6. It's that little bread knife right here sticking into Utah Lake. You can zoom in, you can find your property. If you have a hard time or it's challenging for you to navigate aerial imagery, and you say, I need an address, you can go over here and you can do a search. You just drop down this and say, I want to do it by my address. Someone give me an address that they want to look really quick. Anyone? All right.
1140 west, 600 south.
600 south? And that will zoom to the address. So let's go back here and turn on points of diversion just to see if there's anything. You can see there's a couple points of diversion that popped up in the middle of the roadway. I don't see anything on the land, but if you say you have a well, I would certainly look closely at these to make sure that maybe those are yours. If the guy who owned their property in 1929 was John Gerard, yeah, and you have a well, these wells may be it, but again.
Well's under the freeway, so it's
Okay, yeah.
but there's irrigation.
So do you just get like a storm drain or some type of seep that comes off of the?
There's a storm drain that comes down to
Okay.
ditch is the irrigation ditch, yeah.
Okay, so well, file a claim, and you have shares in a company.
We don't, years ago when I was a kid growing up around that area,
Yeah.
it wasn't Provo City. Somewhere along the line, my deed says when I bought the property, I had 2 shares
Oh yeah.
of irrigation water. And now Provo City says it's theirs, and I have to pay them $22.50
Oh.
for the rent.
They may have bought the company out. They may have,
That's what it probably was.
could have been. Yeah, it happens sometimes. And now they become the owner of the right and administer the shares. So, okay. Any other question? So that's that. Other cool base maps. If you like Google imagery, is a little bit cleaner imagery sometimes. There's topo and stuff. If you want to measure stuff, there's a lot of features on here that play around, click around. You'll find interesting if this is kind of your wheelhouse you like to work around in. I'm just going to check my inbox, make sure there's no more, there's no one's emailed any other questions. So with that, we will consider this concluded. Thanks for attending. If you have individual water right questions, feel free to come up, ask me. I do have some staff outside as well if there's a line or whatever you'd like. Feel free to hang out and ask questions for a little bit, but at some point we've got to hand the rec center back over to the city. Okay? Thank you.